Section 30 read with 33 objections would be filed.
Would be filed.
To be taken up, and on the ordering of the objection and depending on the result, 17 would follow.
Correct. It would be either made decree of the court, setting aside partly, rule of the court, setting aside partly, affirming partly, and for limited grounds, even modifying, because there is a power of modification. There was a power of modification. Now, my lord, come to last but third para, unnumbered para, the second situation. Lord, I'm skipping, my lord, what is not relevant for the present.
Yes.
The second situation is equally unobjectionable, since the power to modify or correct the award is, in this case, linked up with an imperfection of form or an obvious error, and can be exercised without affecting the decision on the matter referred. The situation where an award contains an obvious error is illustrated by a series of cases where the award was erroneously passed against the President of India, while it should have been passed against the Union of India. The third situation becomes necessary by reason of the fact that the award, because of clerical mistake or accidental slip or omission, does not reflect the true intention of the arbitrator. The common link underlying the three situations is the legislative policy of giving effect to the substance of arbitration and the award. It may be noted that Section 15 corresponds to the Code of Civil Procedure 1908, second schedule para 12. There was no such provision in the Indian Act of 1899. It was, my lord, by way of reference by incorporation. The schedule was an annex to the Act. Nor is there any such provision in the English Act. Under the English Act, the court has no power to alter or amend an award. It may be noted that even in India, no such provision was contained in the Code of 1882 in relation to the arbitration without intervention of the court, and therefore the court had no power to amend the award or remit it. It could either file the award or reject the application. In absence of such a provision, the court had either to set aside the award or to remit it. Hence, the need for a provision conferring power to modify the award. The present provision is a salutary one, and we have no change to recommend in Section 15. Lord, Section 15, your lordships would recall, is a power of modification of the award on the grounds mentioned therein, my lord. Then at the foot of the page, 5.7, it may be noted that in the Indian Arbitration Act of 1899, there was no limitation of the grounds for remission. 13.1 of that act was as follows. My lord, ground remission, my lord, your lordships are not right now considering. I will not, my lord, go into that, my lord. Lord, if your lordships, my lord, would consider partial remission, etc., my lord, there is a detailed discussion by the Law Commission, my lord, at page 255. But since remission may perhaps not have the relevance, but since other side may, my lord, put it, therefore, for completeness, I may read para 5.14. The reconsideration under Section 16 may be the whole award, or it may be of a particular question only. If the whole award is remitted, the effective award is the second one. But if only some of the matters are remitted, it becomes somewhat difficult to decide how far the first award remains effective. The question was discussed in a Calcutta case. The view was taken that unless the court gave a direction under Section 16.1 to the effect that the award of the arbitrator should be limited to the matters remitted to him, the arbitrator can, in his second award, confirm or repeat what he had said in the first award. Then skip the remaining two para and kindly come to 5.17. We may now revert to the need for widening the scope of Section 16, a matter which we have already discussed. It is to be noted that at present, when an award which is defective in matters of substance is received by a court, when the only alternatives open to the court are to remit the award or to set aside. Power to set aside the award, in contrast with the power of remission, is a drastic one, because the court may then supersede the reference and direct that agreement ceases to have an effect with respect to the difference referred. Such a drastic action may not always be in conformity with the intention of the parties. It may lead to unnecessary litigation and in some cases to injustice. If this approach is correct, the power to remit should be worded widely rather than narrowly. In fact, this power in the earlier Act, Indian Arbitration Act 1899, Section 13, was very wide because Section 13(1) of that Act provided that the court may, from time to time, remit the award to the reconsideration of the arbitrators or an umpire. There was no further limitation as to the grounds of remission. In the English Act also, the power is expressed as a power to remit the matters referred or any of them without any restriction as to grounds. Now, my lord, this may perhaps not survive because now much water has flown and this issue is also debated and discussed in unsit trial, my lord, which came out ultimately with the model law. But I don't think any other part of, my lord, this report would assist your lordships, my lord, or the other side, my lord. Either way, my lord, it would not be of much assistance. Now, kindly come back to my note, my lord. Now, my lord, I will show how the model arbitral uncitral law, uncitral or unicitral, both, my lord, words are in vogue, came into being, my lord. Because there were page 12
of the note.
of the note. Lord, I may say there was a detailed exercise undertaken by the unicitral. Several working groups meetings took place. Several discussions took place. India also participated in discussion. Other countries also projected their respective difficulties in their domestic arbitrations, international arbitrations, etc. And keeping everything in mind, this unicitral model law was framed, leaving it open for the member states. When I say state, state in the international law parlance, member countries to adopt it fully, partially, or not to adopt it. Lord, kindly come to page 13, para 39. Lord, everything which we now see as Article 34 of unicitral and our Section 34 of the Act is essentially based on New York Convention. My lord, your lordships are aware, New York Convention was essentially for the purpose of enforcement of foreign awards. It did not provide for any challenge procedure, etc. But if it meets with the following conditions, a foreign award can be enforced in another country. Lord, that is Article 5, which I have quoted. Lord, this would be relevant because your lordship would find this reference subsequently when the unicitral model law is in the making. Lord, kindly see at the foot, para 39. Before the unicitral model law for domestic arbitration or international commercial arbitration, the only major international convention on the subject was New York Convention, which dealt with enforcement of foreign awards. Articles of the New York Convention provided the scenarios where the foreign award could be refused to be enforced. Something similar to 34, that if these are the grounds, we will not enforce it. Please read, Madam. Recognition and enforcement of the award may be refused at the request of the party against whom it is invoked, only if that party furnishes to the competent authority where the recognition and enforcement is sought prove that the parties to the agreement referred to in this article in Article 2 were under the law applicable to them under some incapacity. This is one of the ground, my lord, in 34. Just, my lord, as a side reference. Or the said agreement is not valid. Same again. Under the law to which the parties have subjected it to, or failing any indication thereon under the law of the country where the award was made, or B, the party against whom the award is invoked was not given proper notice of the appointment of arbitrator or arbitration proceedings, or was otherwise unable to present. This comes, my lord, in 34, Article 34 of unicitral, which we follow under Section 34. Even incidentally, the section is also same. Number same. The award deals with a difference not contemplated by or not falling within the terms of submission to the arbitration, well, that is terms of reference, or it contains decisions on matters beyond the scope of submission to arbitration, provided that if the decisions on matters submitted to arbitration can be separated from those not so submitted. So severability was sine qua non. That part of the award which contains decision on matters submitted to the arbitration may be recognized and enforced. If it is not severable, the entire award will become unenforceable. This continues in 34. I'll show this. The composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties, or failing such agreement was not in accordance with the law of the country where the arbitration took place, or the award has not yet become binding on the parties, or has been set aside or superseded by a competent authority of the court. My Lord, two, we are not concerned. My Lord, at this stage, my Lord, a need was felt. But I'm not going into the history because that's not necessary. But this is the period of time where, my Lord, these are late 50s, where inter-country trade and commerce became, my Lord, the rule of the day. And therefore, the arbitration and more particularly the international disputes between one party in one country and another party in another country started growing. That required a global framework that you provide for one model law, because each country has their domestic arbitration laws which are at variance with each other. And therefore, my Lord, the UNICITRAL was tasked with the functioning of preparing a model law which can be prepared as a model, and member countries can either with modification or without modification accept it in their respective parliamentary legislation, or they may choose not to. My Lord, kindly take volume 2. Volume 2 again is big, but I am going to read only 7 to 8 pages, some paras from those pages. But I have to put complete working group minutes, my Lord, so that your lordships have the fuller picture. Lord, please come to page 501. Lord, the effort starts from 1976. At para 49. Lord, this is the Asian African Legal Consultative Committee initiated the discussion with UNCITRAL. That's the limited purpose of my showing.
501.
But
501.
501, para 49. My Lord, this is Asian African Legal Consultative Committee. They initiated that UNICITRAL should now come up with a model framework, model law, which can be utilized by the other countries. The problems encountered are sometimes due to the fact, I'm sorry, my Lord Justice Sanjay Kumar has 501, para 49. I'm not reading the whole, my Lord. It discusses the need for having a common, my Lord, model law, but 49 is relevant. The problems encountered are sometimes due to the fact that 1958 Convention, that is New York Convention, does not regulate certain issues. This has on occasions led to uncertainty about the applicable law, that is, in respect of the validity of arbitration agreement, and due to the disparity of national laws to different results. One possible way of important could be to attempt to reduce that disparity by recommending uniform rules which would take into account the specific features of international arbitration agreements and awards. That would be in conformity with the discernible trend of national restraint in international context. Kindly now, my Lord, come to page 502 at 503. My Lord, the Secretariat of UNCITRAL, my Lord, prepares this note. Para 8, my Lord. para 8 at 503. I'm skipping something, my lord, your lordships can take it from me, would not be relevant either for this side or that side. My lord, I am presenting everything in a neutral way. 8. Yet another reason is the divergence existing between frequently used arbitration rules and national laws. This is the area of concern expressed by AALCC, that is Asian African Legal Consultation Committee, in its recommendations. For example, some national laws restrict the power of parties to determine the applicable law. Some national laws do not recognize the competence of arbitral tribunal to decide about its own jurisdiction, or they provide for judicial control over the composition of the tribunal and sometimes even over the application of substantive law. Other laws establish certain nationality requirements for the arbitrators or require the award to be accompanied by a statement of reasons irrespective of any agreement by the parties to the contrary. It is suggested that an UNCITRAL model law on arbitral procedure would, if implemented at the national level, solve many of the problems referred to. It would also establish universal standards of fairness and would thus meet the concerns expressed in one of the proposals of AALCC. Moreover, such a model law would prevent some, if not all, of the difficulties detected in the survey on the application and interpretation of 1958 New York Convention. Finally, the elimination of certain local particularities in national laws, a model law would be relevant in the context of the proposal of ICC to limit the reasons for setting aside awards to the grounds for refusing recognition and enforcement specified in Article 5, Paragraph 1. I read Article 5 of the New York Convention. This is the beginning where the thought process started that even if you give the power of setting aside or you provide for a judicial oversight for setting aside, restrict it to the grounds referred to in 5. Therefore, I read 5 because that is the genesis, that is the foundation of this thought process. If the commission were to agree with the above recommendation, it may wish to request the Secretary General A to prepare an analytical compile. My lord, your lordships can skip that part, my lord. Now please come to, my lord, the Secretary General now prepares a report on 14th of May 1981, which starts at page 401, but kindly come to 519. 519. Lord, I'm skipping the rest because that's not relevant. It's because UNCITRAL was for everything. What is contract? What is arbitrable contract? How tribunal will be framed? How tribunal will conduct itself? When the tribunal's jurisdiction would end? When it becomes functus officio? Fees, etc., etc. We are concerned with the recourse after the award is passed. That is, my lord, this chapter at page 519. Therefore, my lord, I am not reading the rest. 519, your lordships get, my lord.
Yes.
Means of recourse. My lord, from here till date, it's not power of appeal, right of appeal, right of revision, right to seek change modification. The expression continues to be recourse, which is, my lord, in my submission, a neutral term. What is the recourse? Then whatever is the power given will be exercised. Appeal against arbitral award, 102. I am on para 102. The question whether an appeal may lie from the arbitral award is relevant to the question at what point of time an arbitral award obtains the authority of res judicata, as it is called in Article 24 of 1966 Strasbourg Uniform Law, or becomes binding on the parties, which is one of the conditions for the award to be enforceable under New York Convention. As regards appeal to any second instance arbitral tribunal, the answer seems simple. The model law should recognize any such appeal if agreed on by the parties, as is not uncommon in commodity arbitrations. But Lord, kindly pause here for a minute. My understanding is what the Secretary General is pointing out is there are arbitration agreements which provide for double-decker arbitration. if I lose arbitration once, the contract provides for an internal mechanism providing for an appeal remedy. It is that. There are two judgments of this.
Hindustan Copper.
Pardon?
Hindustan Copper.
Hindustan Copper. I recently
Two-tier arbitration.
two-tier arbitration. I recently lost, Malot. Central Trade. On the lighter side.
You recently know, he lost quite some time back. He's just implementing it still.
Yeah, Malot, 1 month back or so. Your lordships are right, Malot.
That is the execution.
Where we lost
Judgment
much
upholding
earlier.
the two-tier arbitration.
Yeah, I lost in 2000 something, Malot. Your lordships
There
are
was a
right.
conflict,
I-
it got resolved.
Only my presence was
Central rate.
Central Trade. Malot, my presence decide Malot, was the final barrier.
But probably this is what is referring to is something different. What it is referring to is the law of arbitration as applicable.
But
Not to, look, this is not referring to the execution part. It is referring to the first stage itself, which is the law of arbitration agreement as applicable in the country or the seat of arbitration.
correct. Your lordships are right.
It's not referring to the enforceability part.
No. The law itself or the agreement itself provide for a two-tier arbitration, as my lord just.
No, even otherwise, the law will not, suppose, let's say, even in England, if I'm not mistaken, they have a concept, still have a concept where the award can be made rule of the court or degree of the court.
I will show the provisions in England. England have deviated from the unsettled.
They have still a provision where you can make it a degree of the court. Then it becomes, or like here, suppose the award is pronounced here. Then you can find, or the seat of arbitration or the law of arbitration as applicable is Indian law to arbitration agreements. Then 34 will lie here,
And 36 also simultaneous.
34 will lie here. It is decided. Then the principle of res judicata will apply. But suppose you want to execute it, say, now in country A, which is a signatory to the New York Convention, in country A, the party which is defending can take recourse to 48.
Correct. Even we, in international
to that
arbitration, we
extent-
can take recourse to.
But till 34 is decided,
Correct.
possibly you can argue, you can't have that award enforceable in a foreign country.
Unless that country's arbitration law permits. For example, in an international commercial arbitration.
May not be, because if we go by what is stated over here, that recourse, because till then it doesn't operate as res judicata. For res judicata, there has to be finality of proceedings.
Functus officio, the tribunal
There
becomes
has to be finality of proceedings. As long the matter is sub judice, it's not res judicata.
the arbitral tribunal, the award is res judicata. The tribunal becomes
If
functus
the
officio.
award is under challenge and it is pending consideration of the appellate forum, say the appellate tribunal, or for that matter 34,
Correct.
it will not operate as res
As res judicata, but the tribunal would become functus officio. Therefore, that is also a discussion. That while remitting, what happens, because the tribunal no longer exists. Therefore, the word used is to resume, the court would direct the tribunal to resume the arbitration, not continue the arbitration, because you have already become functus officio. Then, my lord, 103. The answer is more difficult, however, in respect of any appeal to the courts. My lord, this makes it clear that first was internal appeal under the agreement.
Let's be very clear. The appeals against an arbitral award is one chapter, which is one heading. The second heading, number 2, is remedies against leave or for enforcement. That's the execution part.
Correct.
So that's the first part deals with the appeals against arbitral tribunal, which can be to a appellate tribunal, arbitral tribunal, or maybe in form of appeals which are provided
In the law,
in the law of that country.
the statutory appeal of the domestic law.
Domestic law.
But instead of 34, we possibly, hypothetically, could have provided for an appeal, first appeal, my lord, against the order of the, against the arbitral award. That's correct.